We are now recording.
Good afternoon and welcome everyone to our final CS Bars meeting for this year. At this time, if we could ask staff to do a roll call vote to establish quorum, please.
Dr. Bolton? Dr. Bolton?
Yes.
Dean Dolan? Not present. Dean Frankfurt?
Present.
Dean Hunt?
Present.
Paul Kramer?
Present.
Dean Marshall?
Present.
Dean Yaroshek?
Present.
We have a quorum, Chair.
Thank you. At this time, we'll call for public comment. Members of the public can make written public comment submitted to csbars@calbar.ca.gov. Possible to mute Mr. Bolton? He has some wind noise. Thank you. We have not received any public comment prior to this meeting. Verbal public comments of up to 3 minutes will now be taken. First, recognizing any individuals who signed up in advance using the link on the agenda. No one signed in advance, or by raising their hand or raising the hand function on a computer or **9 on a phone. Is there anyone who would like to make public comment at this time?
There are no hands raised at this time, Chair Frank.
Thank you. So we'll move on to the chair's report, the first agenda item, item 1.1. It'll be a little longer for me as this is our last meeting, and I like to reference some of the things that have changed for the better and for worse over time. So first and foremost, thank you to the State Bar staff and committee members. This is my final meeting for the second time as the chair of the committee, and I'm very appreciative of all the help and the collaborative process that we've had over the years in improving hopefully California and our legal profession, right, as we go through. I'd also like to have a special personal thank you to Dean Yaroshek, who is our interim interim chair for our last meeting that I could not attend. And thank you to Dean Mesqua, who has completed his portion of this committee work. And a thank you to Dean Dolan. Hopefully he will be able to join us today as we go through for his interim appointment that will end in this meeting. So this will be my final meeting and Dean Dolan's final meeting. A new chair will be, and new members will be selected by the new chair and new vice chair of the Committee of Bar Examiners after they're appointed in the coming weeks. Then a new CS Bars calendar will be set for the 2025 to 2026 year. New members are chosen from the pool of applicants that applied during the application period, which closed on June 30th. Applications received now will be considered for the 26-27 year. Unfortunately, a bit of bad news, and I think most of us in our community already know this, but I thought we would take a moment of silence to honor the untimely passing of Dean Don Deckel from Thomas Jefferson School of Law. And now for the good news, we can welcome some new deans to our California Law School environment. For Empire College School of Law, we have Dean Fiona Hall. For Monterey College of Law, Dean Elizabeth Zier. For St. Francis School of Law, Dean Charles Katz. The College of Law, Dean Brandy Price. And for the Thomas Jefferson School of Law, Dean Linda Keller, who is returning to her deanship. So hopefully,
Frickberg, may I add another dean? Welcome to Dean Bernadette Agaton from Abraham Lincoln University School of Law.
Oh, absolutely. And I think, at least in my experience in California, I think this is a record of new deans joining within our group. So I would definitely like to invite them to attend all the state bar meetings, the committee bar examiners, the CS bars. I think they're very helpful. Be part of the change you want to see in our community, right? I think it's very important to do that. Join the email notification list and consider applying to these committees, including the CS bars in the future, please. Let's see. And looking back and talking with the staff at the bar, it's amazing how many things we've impacted or been part of, I think, in the past year as we went through, just to highlight a couple. There's the law school performance report and key metrics. I think was excellent for the staff and the CS bar's interaction. Post-exam surveys from the state bar. Now consistency for bar pass rates with the NPR for both accredited and registered schools. Recommending implementation changes to reset. That was the bar retaker support group for the Lawyers Assistance Program. Again, the excellent work the Lawyers Assistance Program is doing and what the CS bars can do to amplify that. I think like many, we receive lots of emails. Our students receive lots of emails. So if we on the CS bars, if deans of law schools can amplify those and say, please, they're trying to help you. The bar is here to help. I think that goes a far, far way for them. We amplified the ability of the additional state bar systems, such as the imposter syndrome toolkit, which I think is excellent. Many suffer from that, and it gives them, some sounding board ideas on how to improve, again, personally and professionally, as well as increasing graduates' participation in state bar programs like bar strategies and stories and peak performance. And of course, the provisional licensed lawyer program we're going to talk about today in agenda item 2.1. Also, as many experienced with the difficulties of the February bar, I think the CS bars and staff was a critical communication pathway for many to make sure the information was accurate and consistently given to graduates and the amazing amount of bar passers we all had. Also, the opening the discussion of AI practical guidance, which is radically changing all of the time. But every time I review it, there's something new, right, as we go through that process. We've withdrawn item 6.1 from today's meeting, but that will be a continuing discussion point for the CS bars going forward, as it is for our entire legal profession. Reminder that this Friday is our CBE meeting. Again, that'll take place in San Francisco and be online, especially for those that are new to their deanships. I would encourage you to participate. And this is an excellent point where you can make public comment, either in writing, preferred always by all of us that are in committees, or orally at the date of the event. With that, I think we'll move over to our scheduled adjustment items. And I do not believe Dean Dolan has joined us yet, so I think it would probably be better for us to turn over to Donna Hershkowitz at this time for agenda item 2.2 and item 6.3. I think you're muted, unfortunately.
Someone's always got to be the first. Thank you, Dean Frickberg, to the members of CS Bars. For those of you who don't know me, if there's any, I'm Donna Hershkowitz. I am the Chief of Admissions and Legislative Director here at the State Bar. I'm going to start with item, I think it was 2.2, the recommendation to the Supreme Court regarding the proposed amendments to the California Rules of Court, Title IX Rules of Court. Let me share my screen. And then let me just get that in the presentation mode here. Are you seeing anything different now than you were initially?
Yes, a recommendation to Supreme Court slide.
So we'll go ahead and move through these slides. So at the August 14 joint meeting.
Still not in presentation mode, though.
Yeah, that's what I was afraid of. We're just gonna leave it like this.
I think top left under file from beginning.
We're just gonna leave it like this. At the August 14 joint meeting of the Board of Trustees and the Committee of Bar Examiners, the committee and the board both considered the recommendations that the Supreme Court made to change various provisions of Title IX of the Rules of Court. Most of those were admissions related provisions, and it was to respond to this proposal that was the impetus for the joint meeting between the Committee of Bar Examiners and the Board of Trustees. At the meeting, recommendations were made based on prior discussions that both the board and the Committee of Bar Examiners had, and most importantly, public comment that we had received after putting the proposed rules out for a 45-day public comment period. The rules were proposed by the Supreme Court at the end of May, and at the conclusion of the 45-day public comment period, we had received in theory, 99 public comments. Of those, several of them had no content at all. Some of them had identity information of the public commenter, but no other information, no other comments, or no other statement that they agree, disagree, or agreed is modified with the rules. So ultimately, we were looking at 25 comments that had stated positions or comments, whether or not with identity information. And the Committee of Bar Examiners and the board, as I mentioned, made recommendations that are being developed, that are being put into a petition to the Supreme Court. And those recommendations were based on their prior discussions, the public comment, and then the recommendations staff provided. What I'm going to do for you today is go through the rules at a high level, just talking about the general subject matter of each grouping of the rules as we've put them together, as we've organized them, what the original rule provided, and then what the recommendation was that was adopted by the board and the Committee of Bar Examiners, and that is being forwarded to the Supreme Court. The first category of rules that we put together, the rule changes, were changes to rules 9.3a and 9.5a, which had the effect of narrowing the state bar rules that required approval by the Supreme Court, by limiting it to those rules that dealt with prerequisites to the admission to the practice of law. That suggested to us that the rules that would not be required to be reviewed by the Supreme Court include those on testing accommodations, special admissions programs, conduct violations, i.e. Chapter 6 rules, rules relating to law school accreditation and regulation. The action taken, what was recommended, the Committee of Bar Examiners and the board did not recommend any proposed any language change to the proposal from the Supreme Court, but did recommend that as part of the petition, we seek guidance to get clarity on to get real clarity on which rules would and would not be required to be submitted to the Supreme Court for review. You probably heard me say on the last slide, presumably this includes areas such as, and so we want to have complete clarity for ourselves as well as for the public, as we review rules in the future, so people know what the next steps are for those rules and where they can raise comments. The next grouping or category of rules that we put together were those rule proposals that affected the oversight and development of the bar exam, and specifically this is proposed new rule 9.6. The rule specifies various responsibilities of the Committee of Bar Examiners in administering the bar exam. Specifically, the rule provides that the committee may use a third-party vendor to prepare bar exam questions, that the committee needs to develop standards for content validation panelists and subject matter experts for review of the content of bar exam questions, that the committee has to develop standards for assessing the ability a third-party vendor to administer or to proctor the bar exam, develop and maintain standards regarding testing accommodations, and also oversee the grading process and develop standards for regrading or scoring adjustments. Each of those items pursuant to the rule was made subject to review and approval of the Board of Trustees. So any recommendation that the Committee of Bar Examiners would make would then have to go to the Board of Trustees. We received a lot of public comment on this rule from law school representatives, from members of the public as well. And following that and looking at that comment, I'm sorry, there's more. This was a hefty rule. In addition, the rule also required the Supreme Court to approve any changes to the bar exam that require substantial modification to the training or preparation that's necessary for passage of the exam. And it required the Committee of Bar Examiners to conduct a cost-benefit analysis for any changes to the bar exam that were described on the last slide, and any changes to the format, mode of delivery of the exam. And then specifies the elements that need to be included in that cost-benefit analysis. So again, we did receive quite a lot of public comment from law schools, from law school representatives and others with regard to this rule. And based on that input, several recommendations are being forwarded to the Supreme Court for some modifications to those rules. One is having a clear statement that contracts for a third party to develop questions for the bar exam are required to include a conflicts of interest clause to ensure that the vendor does not have an inappropriate conflict. I would say that this is part of standard operating procedure. Our contracts would always include such a conflicts clause, but understand the absolute importance of it and agree that that should be moved forward to the court. There was also a recommendation that we publish the qualification standards for content validation and subject matter experts that are involved in the validation of the content for the bar exam, as well as publishing our grading and regrading policies. These were all these top 3 bullets were all recommendations that came from law school representatives, and the committee of bar examiners and the board agreed that those were all things that should be advanced. Also, we added a specific requirement that we consult with law school stakeholders on bar exam development and administration, pursuant again to a comment by some law school representatives. The committee of bar examiners and the board also are proposing eliminating the language that I referenced on the prior slide that would require the development of standards for testing accommodations. The rationale for that is that when we were developing in 2022 and 2023, developing the new requirements for the rules on testing accommodations, there was a framework and standards that were being developed, and the bar received significant public comment opposed to any standards, anything outside of the rules itself. And so we are proposing eliminating that piece of Rule 9.6 is in response to that experience that we had with the public. The board and the committee of bar examiners are also recommending to hone in on the most appropriate place where the cost benefit analysis must be performed. And that would be we must perform the cost benefit analysis when there are changes proposed to the exam that would require substantial modification or training to the preparation necessary for passage. So one of the as an example of why we propose that, one of the items that would have been subject to the cost benefit analysis would be if we had developed standards for content validation panels and subject matter experts, that arguably would have been subject to having to do cost benefit analysis. Really doesn't lend itself to that. It's quite a lot of work to do that. Unlikely that we would come up with much of anything of value in that kind of cost benefit analysis. And so we are recommending narrowing the cost benefit analysis to those things that impact preparation, substantial modification of the preparation necessary for passage of the bar. And also we're proposing to eliminate what was recommended as a role of the Board of Trustees in grading and scoring. But this was one of those things that would be that was recommended that CDE do that would be subject to review of the Board of Trustees. It is not a role that the Board of Trustees has played up until now. And there's certainly a concern that some of those items might be very time sensitive, and having to go from the committee of bar examiners to the Board of Trustees could be problematic in terms of the time required. The third grouping of rules that we looked at were those rules that the Supreme Court proposed that address the administrative and fiscal authority of the Committee of Bar Examiners and the Board of Trustees. In summary, those rules required the Committee of Bar Examiners to regularly review the revenue and expenses for the admissions fund, and also to propose a budget for the Office of Admissions. Also gave the Committee of Bar Examiners authority to set bar exam fees for certain admissions programs. The proposed rule identified a list of fees that the Committee of Bar Examiners would be responsible for. And additionally, there was language that was put in that would restore the authority of the Committee of Bar Examiners to conduct hearings, conduct hearings, administer oaths, or compel attendance of witnesses or production of documents. In talking about those requirements, those new rules, and the public comment about those rules, the Committee of Bar Examiners and the Board of Trustees agreed to forward the following recommendations for slight changes to those rules to the Supreme Court. First, and I'll take this in the same order that I described them, which is not the order on the slide. Clarifying the committee's that the committee's authority over the budget is subject to review and approval by the Board of Trustees. There were some conflicting public comments. One that just said clarify who's responsible and what because there was a feeling like it wasn't unclear. There was another public comment that suggested the Committee of Bar Examiners should really have the primary responsibility over development of the budget for the Office of Admissions, and that the Board of Trustees would have to agree with the proposal from the Committee of Bar Examiners absent extraordinary circumstances. There was a proposal that if they couldn't agree, that there would be mediation. The Board of Trustees has primary responsibility over the budget for the entirety of the bar. And the recommendation was clarifying that CBE's authority to propose a budget is subject to the review and approval of the Board of Trustees. Also, the recommendation that will be advanced to the Supreme Court is to broaden the CBE's role in setting fees. It is subject to approval of the board as set forth in the Supreme Court's proposal. But as I mentioned in the last slide, there was limiting language on very specific fees that were identified, and we struck that language and just gave CBE broader authority in that sense. With regard to what is the top bullet here on the page, what was recommended was that not a change in the language per se, but just that we point the Supreme Court to make sure that they evaluate the authority to provide by rule the authority for CBE to conduct hearings, administer oaths, and compel attendance. And the reason that we are suggesting that is that that was statutorily authorized up until 2018, I believe it was. And that was removed from statute. And so we have not completed the research, obviously, and defer to the Supreme Court's analysis of whether they can by rule restore that authority that was repealed by statute a couple of years ago. And we just wanted to make sure that they were looking into that. And the final big grouping of rule proposals that the Supreme Court made had to do with governance, delegation, and appointment procedures. Included in this rule package was a rule that would direct the Committee of Bar Examiners to recommend to the Board of Trustees any candidate for the Director of Admissions. There were provisions that dealt with the Supreme Court appointments and to the Committee of Bar Examiners itself. And specifically, the Supreme Court had added language that said that the Board of Trustees may not nominate to the Supreme Court for appointment candidates who are professors of law actively involved in bar exam review or otherwise assisting applicants to meet requirements for admission. Also, the rules authorize the Committee of Bar Examiners to delegate any of the duties that were set forth in some of the prior rules that we've discussed, to delegate those duties to a subcommittee as necessary. The easy one here certainly was the first item. We were just recommending a slight change to the proposal to make it clear that the recommendation from the Board of Trustees, from the Committee of Bar Examiners, would not be about the the Director of Admissions position, but rather the Chief of Admissions position, which was a newly created position this year, as the sort of the top level executive over admissions. It made sense that this would be the position that the Committee of Bar Examiners would have a role in recommending. And also we recommended that the recommendation go to the Executive Director. The Board of Trustees is actually not involved in selecting that role. The Board of Trustees selection is limited to the Executive Director of the bar, the Chief Trial Counsel, and the General Counsel. And so we just adjusted that recommendation slightly. One of the comments that one of the provisions that I just mentioned on the prior slide that we received significant public comment on from law school stakeholders was the limitation on being able to nominate members for CBE who are law school professors or are involved in bar exam preparation. We did not, the Committee of Bar Examiners and the board did not make a specific recommendation on that language, other than taking the recommendation that came from one of the law school public commenters to change the language to clarify to clarify the terminology for how we refer to that law school faculty. But this being that this was the Supreme Court making a recommendation, making a rule change as to who it has the authority to propose to appoint to the Committee of Bar Examiners, it didn't seem appropriate for us to make a recommendation to change that. An additional recommendation that we did make with regard to the committee, to the appointments of the Supreme Court, is providing language that would give the Supreme Court appointees the authority to hold over, which means when their term ends, to continue to stay in that seat until a new appointee is seated. This is something that appointees from the governor and the legislative branch do have the power to do. This was recommended by one of the Committee of Bar Examiners members. And finally, with regard to the delegation to a subcommittee, there was some feedback that that any item that was delegated by the CBE to a subcommittee would only be effective until the next meeting of the committee, the next regularly scheduled meeting of the Committee of Bar Examiners, and that at that meeting, the Committee of Bar Examiners would need to ratify the action of the subcommittee. And if they did not, then that action would be undone as of the date of the Committee of Bar Examiners meeting. Instead of doing that, the Committee of Bar Examiners and the board recommended adding language that says that the action taken by the subcommittee must be reported to the CBE at the CBE's next full meeting, but that there's no ratification of that action that is required in order to ensure finality of the decision that was made by the subcommittee in those cases where the CBE delegated authority to them. There was one other item that one of our members of the Committee of Bar Examiners pointed out. This was not an amendment that was made by the Supreme Court, but in looking at all of the rule changes, and the Supreme Court had proposed some non-substantive amendments to Rule 9.30, which relates to the Committee of Bar Examiners oversight of unaccredited law schools, and the Committee of Bar Examiners member who took a look at this thought it was time to eliminate the specific requirements that were in the rule about the contents of the libraries at unaccredited schools. The information felt a little dated, and so the recommendation instead is language that would give CBE the authority to determine the breadth of materials that must be available, and not have it set forth in rule. That will give us greater flexibility to make changes as appropriate, and to deal with the fact that, right, if the school is fully online, perhaps there are fewer materials that are physical materials that are needed in a physical library, and wanting to make sure that we have the opportunity to address that. So those are the rules that were recommended, and the actions that were taken by the Committee of Bar Examiners and the Board of Trustees on those rules, and I'm happy to take any questions.
Not hearing any questions or seeing any hands. Thank you, Chief Administrator Sershkowitz, for shepherding us through that odyssey of proposed amendments. It's definitely appreciated. I think we will now turn to our next item, which
So
is
I believe that we have Dean Dolan. I think that he may be in the audience using the cell phone. Dean Dolan, if that is you, could you press *9 and raise your hand? Let's see. And I'm thinking, is 4007, phone number 4007? I apologize. Oh, yes, that this is Dean Dolan, so we will go ahead and promote him and he will appear via audio. He is balancing court commitment.
So, welcome, Dean Dolan. Are you able to hear us? You're muted if you can hear us.
Lisa, are you able to unmute him? I don't have the controls on my panel.
Yes, I can only ask to unmute, which is what I've done.
Okay, great. Thank you.
Star 6.
Excellent.
Very nice. Thank you. Yes, I've been here since the beginning.
Thanks, Dean Dolan. We're glad to hear you.
Sure. Sure. I'm glad you can be heard.
Welcome. And if it is okay with Donna Hershkowitz, if we could return back to item 6.2, then go back to, okay, perfect. Thank you. Let's turn now to agenda item 6.2. We were going to have that earlier. This is concerning the first year law students exam. If we could bring onto our share screen as possible. Excellent.
Thank you. And we might have some background noise because Dean Dolan is in court, but this is also how we will get Dean Dolan. So thanks everyone for your patience with that. So this
Sorry
item,
for my noise.
well, we're glad for your thoughts, which we'll be sharing shortly. So this is a discussion regarding the timing of the first year law students exam. It's a referral from a prior CS Bars meeting based on a concept that was raised by Dean Hunt. He asked about what some of the factors could be in evaluating whether or not the first year law students exam could or should be given more than twice a year. The item was not agendized for discussion. So today it's agendized for discussion and a potential action, although I understand from a brief preparatory conversation with Dean Hunt and Dean Dolan, at that time they thought this might be a more preliminary conversation. So
Yes.
yeah, okay. All right, so I'm going to turn to the first slide that will just talk about the work plan in general. And on my screen, I'm seeing that the slide is larger than the space available. I'm not sure if we can cut it down so the public can see, and if not, not a problem, I'll talk through it. So we're looking at whether or not the CS Bars would like to recommend that the CBE prioritize looking at the frequency of the first year law students exam. So staff has taken some time to brainstorm and work and support Dean Dolan and Dean Hunt to see some of the factors that might need to be thought about. Now, everything exists in the context of everything else that is going on. And because we have many new deans, many of whom are in the audience today, we're going to step back from the issue for a moment and just talk about the process in general, that each year the Committee of Bar Examiners creates a work plan. And almost every year, there are more things that the committee would like to do than there would be time or resources to accomplish. So normally you're looking at a number of different possibilities all at once, but here to get a little information before that prioritization conversation, we're having this additional discussion here. So once the new chair and vice chair of the CBE are selected, which should probably happen toward the end of August or beginning of September, they will solicit work plan items for the 25-26 CBE year. And that work plan always includes referrals to the Committee of Bar Exam, to the CS Bars. That will happen again this year. So when you're looking at this item today, the first year law students item, you'll think about it by itself, on its own merits. but also know that a conversation will be coming very soon about all the different recommendations you might make and how you might as a whole prioritize these recommendations to the Committee of Bar Examiners. And then I wonder, I think possibly the slideshow choice from current slide might show the full slide. Okay, gets us partway there. Dean Frickberg, would you like me to go through this one or would you like to take this slide?
No, I can discuss this one if it, the first year law students exam, informally known as the baby bar. So sometimes people confuse these issues as we go through. It's just an informal name for it. Is administered in June and October, as compared to our general bar exam, the GBX, which of course is February and July. But as we go through that, there's always a delay from when an administration occurs to when it could be scored and released as we go through. So I think one of the concerns that I would have in this dialogue would be, just first staffing for the bar. As we space out these administrations of first year law students exam, general bar exam, there's peaks and valleys. I think we're all used to that in the law school environment of seasons, admissions, final exams. So if we add additional testing scenarios, what workload will that put on staff at the same time? Separately from that, it's a smaller group, as I think we'll see as we go through the numbers in a little while, that will actually sit for the first year law students exam. And would an additional administration benefit them? Because as we're going to discuss under the Business Profession Code 6060, they have three opportunities to take and pass. Those that are required to. And again, the default is everyone is required to take and pass the first year law students exam unless they have an exemption, right? And the only exemption that will exist will be, are they a regular student as compared to a special student, term of art definition, as well as did they complete their first year in good standing and were they allowed to matriculate into that second year at an ABA or CalBAR accredited school? So it's a very small niche area as we go through. And will that be to their advantage? Because many will continue their legal studies during the pendency of sitting for the first year law students exam. And this will give them additional time in their studies, in their second year of law study at a registered unaccredited school. So if we have all three administrations in the same year, one, are they having enough time to study for them? Similar to the bar itself, where we need at least 2 months of preparation time, enough preparation time if there's multiple administrations. And then secondly, is it benefiting them by cutting the actual time that they would have? Of course, with all the statutory implications. For me, that's the broad overview, I think, and we can go into more minutia as we continue. So currently the exam fee is $873. I think they changed that. Was it approximately a year ago? I want to say. I think that's when it increased. I have to double check that one. And again, from a law school perspective, if we give more exams, that might dilute the savings of having only 2 administrations, right? If we can know we're gonna have 2 administrations per year, if it was a law school, then I can budget for that. If I have 3, now I have to budget for additional proctoring, exam, grading, and I lose some of those benefits of coalescing these as we go through. Are there other factors? I'm not sure. I think we can have our public discussion on that one as well. And our next.
I would like to make a comment on other factors,
Oh, please.
if I may.
Absolutely.
It seems to me that in our present format, where it's multi-state only, that the Scantron evaluation should be much more rapid than reading exams. And so we should be able to get results to students faster than before. So if they took the June exam and got their results, let's say by the end of July, we could schedule then again September, and then the results we could schedule again November, and then the results we could schedule again March. The purpose being that these young people in their first year get very disappointed. And frankly, I don't think there's more time necessary for the 3 subjects. I mean, obviously they got to bone up on it each time, but the 3 subjects are still the 3 subjects. And it seems to me that to relieve the first year students of the burden of being eliminated if they don't pass the first three administrations would be a good thing for our students. And it shouldn't be that much trouble to add 4 instead of 3 for the 1-year period.
Well, and again, correct me if I'm wrong, but I might be hearing two different discussions. One that I'm aware of that we're supposed to have currently, should there be additional administrations of the first year law students exam offered other than June and October? What I just,
Right.
correct me if I'm wrong, was potentially having 4 administrations as part of the business and profession code. Was I hearing that incorrectly?
That
or-
was my suggestion. That
And
was
I-
my suggestion.
And I think that might be a different one that
Agreed.
that did occur once, just for everyone's memory, during COVID. There was an amendment to the admissions rules because they were having difficulty administering exams at the beginning of COVID. I believe that was the 2020 administration. And I
Right.
believe Leonard had a comment she wanted to make.
Oh, no, I didn't. You do reference correctly that during COVID, on very short notice for the first time, the exam went to an electronic format. So the Supreme Court created an allowance to allow students who are taking the exam for their first, second, or third time then to have 4 opportunities to take the exam. Fortunately, that very first online transition went very well. And we did see many people were not needing to use that 4th opportunity, but it was available on a one-time basis. I do see Dean Hunt's hand raised, though.
Thank you. What I have noticed in general, our students, a student who completes their first year, let's say at the end of the calendar year in December, when the law school first opened 19 years ago, I thought, ooh, those students have a big advantage. They can study from January through June to get ready for the first year law students exam. And having that additional time will really benefit them. And we have found the inverse is completely true. That the longer gap they have from their first year information, from their first year courses, the less successful they are. And so by adding an exam sometime in late winter, early spring, it would eliminate that gap and therefore improve results. And sort of tying into the idea of that is, if there were 3 administrations of the exam a year, a student, regardless of when they complete their first year, they're not going, as it's currently set up, if things break just wrongly for the student, they can be all the way into the middle of their 3rd year before they fail it for the 3rd time. And that's a lot of tuition and a lot of courses that are taken prior to the 3rd non-passing of the first year law students exam. Whereas if, okay, they get to their end of the 2nd year, they've had 3 shots at it, they're not going into 3rd and 4th year courses just by not having passed the exam. So I think having a 3rd exam in some time, and I know timing wise, because the February one is there, whether we can get it graded quickly enough so that they get the results and then can process and be ready again for the June exam. Those are administrative things that are more on the bar to answer. I can't say, but I don't see the gap as a negative. And by having the 3rd exam, we're protecting students from getting into their 3rd year, middle of their 3rd year of law school before they lose all that study. So those were the points I sort of had tied into that.
Thank you. And just as an example from that dialogue, if we have our current administration of the first year law students exam in June and October, the natural midpoint then would be February, 4 months in between each. February is the same time as the general bar exam. And that's the concern I was alluding to for staff and again, potentially the subject matter experts the internal edge team who might be creating some of the multiple choice questions from the first year law students exam, since they're not using MBE questions. Is there a sufficient database? What is the cost going to be to create those questions and to administer, and does staff have the bandwidth, as it were? Those would be the concerns I'd have on law school side if I was doing this in-house.
I understand all those issues. I really do. Tied into Dean Dolan's point, maybe because it is strictly a multiple choice exam, the results can be turned around quicker. Though I know that I'm going to mispronounce the words, the psychometricians who review the exam and determine which questions are valid and which questions aren't, based on how well students do on those questions individually. I know that takes time, and I understand that process. So I don't know how much it can be accelerated here simply by not having an essay component. But I can say from a student standpoint, both financially protection wise for tuition and from a likelihood of passing, the large gap just isn't positive.
Understood. Dean Dolan, I know you had a reduced time availability today. Is there anything further you'd like to discuss on this area before I ask for additional comments from our committee?
Well, I would like to emphasize two things. One is, I think because now we're in the strictly multi-state mode, that we should be able to make a contract with the people who are developing these for an additional exam or two. In other words, there's 200 or whatever, 100, 200, 300 that are developed. We just make that part of the contract that they develop more so we don't have an overlap. And the other thing is the quickness of the exam through the Scantron would give our students plenty of time to then reassess their work as far as going to the next sitting. And I just think for the first year students, it's so important to give them the greatest opportunity to get past this, because I don't like that, what Dean Hunt was saying. I don't want people in the third year. We tell people if you don't get it done by the end of your second year, you're not here, you're out until you get and pass it. And I don't know if that's an overall rule or not. It's 3 offerings. And I just think it's much more fair to the students, and especially with singularly multi-states, it would be much more efficient. I don't think it would add too much to the staff's work, although I don't know that for sure, to have the Scantrons run. And I get the psychometricians need to look at it, but it can't take that long that it wouldn't be a couple of months. And so I believe it would be really good for the students from their point of view to have more than 3 opportunities, maybe 4.
And I think you said you had 2 points. That was the first one, just the time ratio.
Well, the first one is the Scantron and the time ratio. The second one is the timing. But let me make a third one. I think the cost of the exam needs to be looked at, especially for multi-time takers. I understand the first cost needs to be offset, and that's fine. But I think it's not completely fair to the students who didn't pass it the first time to charge an additional $873 for the next time and the next time and the next time. There should be some reduction based on multiple takers.
No, just from my observation, I believe this was our 3rd administration of the current multiple choice question only first year law students exam. And it's still taking
Yes.
about a month and a half to 2 months under these ideal conditions with existing first year law students exam questions. So I think one of the unknowns, at least on my side, maybe on the committee side for this group, are we recycling multiple choice questions for the first year law students exam? I presume not. So they're creating new ones as they go through this cycle. How long does it take to create those multiple choice questions? Write them, because again, they're not NCBE, MBE questions. Right? These are first year law students contracts towards and from not only multiple choice questions for this test. How long does it take for the subject matter experts to go through and vet them? The SMEs, as the psychometricians like to call them, and then actually administering the exam, doing your correlation studies to determine, was this a valid test as to those multiple choice questions. That itself, I don't know if they can really get that less than that month and a half, 2 month time frame that we've seen over the last 3 administrations. I don't know if anyone from staff has any thoughts on that. Is that a fair observation from my side?
Oh,
Um,
I'm so sorry. Natalie. We actually have an item bank of questions. So we have questions that were developed over time and reviewed, and then so it's not every iteration that new questions are developed. And because of the way you score multiple choice tests, there are questions that you go through multiple administrations because we use those for equations. So some of the questions would be in the June and the October thing, because when we look at administration over time, because we have a question for that. Okay, so anyway, that was all I was saying.
And it's possible that sometimes when topics are discussed, they stay in the unitary manner or they end up being broken up into pieces. And so it might be that a next step could be specifically to look at the grading timeline right now. Is there any flexibility in the grading timeline, the exam development timeline right now as a standalone project? Because depending on the outcome of that, that might help to inform the feasibility of additional first-year law student examination administrations.
I agree.
Also, is it possible to bring back our slides? Again, just in case everyone didn't have an opportunity to look at them. And if we could go forward just to see the actual head count, as I would call it, the number of examinees to see. There we go. Thank you. Perfect. So for the October administration, the last one that we have numbers for, that was the October one, 228. Right, 228. The prior one, June 24, 243. So these are rather small values. So if we're looking at a 1-year administration, that's under 500 in a 1-year administration. So if we make that into 3 smaller exams as a potential proposal, is that a sufficient quantity to justify a 3rd administration? Again, if it coincides with the February general bar exam and the difficulties that could create. So potentially, I think the next steps could be, is there additional information the CS bars would like to hear in this area? If we could go forward a couple slides, please. I think we already discussed the statutory role, probably factors to consider. And I think we've touched on most of these already just within our dialogue conversation between Dean Hunt, Dean Whelan. We can actually back one step, please, just to make sure. Yeah, the statutory change need. I think that's one of the bigger concerning ones for me, because again, business profession 60/60 specifically has that 3. It again, not the exams they sit for, but the 3 that they qualify for, regardless whether they sit for them or not. So that time is running. Development validation, that was my concern, and just creating exams myself and understanding the difficulties in that process. Timing of grade release. We discussed that. Student interest and availability to study for the exam. That could be another area we could discuss. Should there be a survey? Should there be some type of survey administered for those that sat for the first year law students exam or are likely to sit for it in the next year? Would they even be interested in this? Maybe we on the academic administration side are interested, but the students aren't. So that could be another area that we could discuss. Impact and costs, I think we discussed that. Prioritization over other possible projects. Again, just return on investment of the time of the CS bars. Is this what the best use of the time for next year? If we can go to our next slide, please. So are there pros and cons that we have not discussed that anyone in our committee would like to bring up for this discussion now? We can go to our next slide then, hearing none.
Pros and cons.
Would we like to entertain a discussion of potentially asking for surveys of schools or surveys of students? Would that be something that's helpful or beneficial to this group?
Yes.
So I think I hear one yes. Any counterpoints? Any further discussion on that? And so I guess we could ask staff just for the feasibility, just to look into, is it feasible or helpful on the staff side to do a survey of schools and or the students would sit for that administration?
Yes, that would be something that we could share, potentially on its own or in connection with some of the law school engagement things and sessions that we are doing to get some feedback about how it's being used and if they see any advantage to a change in the schedule.
Thank you. And if we can go one more slide forward. So now these are the potential recommendations we can have today, unless anyone has a further discussion point they would like to raise or a question, of course. We can identify further information needed by CS bars, hence the survey conversation we were just having. Recommend further study to the committee of bar examiners, ask them to review it. Decide not to recommend at this time, or hold consideration until the fall CS bars to consider in context with other priorities. So of those 4 options, which I think is humorously appropriate because we're talking about a multiple choice question test, A, B, C, or D, which would our committee prefer? Any preference there for discussion?
All of the above.
All the above. That would be E. Dean Yaroshek, I see your hand up.
So I think it's premature to recommend to the CBE for further study. For me, I think it would be nice to get more information in terms of feasibility, cost, as you said, investment of time. I don't know. We don't know what the other priorities will be for this next year. And so I think needing that information before putting this idea onto the work plan. So from my perspective would be identifying the information, so the survey, and then holding off until we have a list of priorities.
Dean Hunt, you have your hand up next.
Despite the fact that this is my idea, I don't think it's ready for proposal to the Committee of Bar Examiners for consideration. Obviously, we need to find out way more feasibility working with the state bar to find out what the expense of developing the questions would be, the length of time that would be needed to, if this is something we're tagging maybe 3-4 years out from now, we can start preparing for it. The questions can start being developed and implemented that far out, so that when we do move forward with it, it's a plan that makes sense. Whereas right now, obviously, it just sounds like a great idea, but it certainly needs to be fleshed out so that we know what the expenses are, we know what the hurdles are, and how. And I understand. To me, the number one question is, where does it get put? Can we do it on the same Wednesday that we do the MBEs with the bar exam? And on that day, we're doing the baby bar and the MBEs on the same day? Or is the state bar going to go, oh my God, that's the worst idea I've ever heard? And then, well, can we move it up a week? Can we move it back 2 weeks? I don't know that, but those are things that we would have to discuss with the bar in how they administer the baby bar and the bar exam, and when would be the feasible time in late February, mid-March that we could do this. Once we've got a date and we can look at a timeline for when they would get their response, making sure that they get their grades prior to the application deadline for the June exam, we can spell those things all out and hopefully create a plan that everybody thinks is logical and will result in better first-year law student exam results and better protection for the students so they don't get so far into the program prior to losing their studies if they unfortunately don't pass on their third opportunity.
Thank you. Dean Marshall?
Yeah, it seems to one of the pieces of information that we need. I'm looking at A, identify further information, and I'm tying it to D. It seems to me that this is going to be a pretty complicated, heavy lift. And it would seem to me that the information we need is what are the other priorities that are sitting on our plate in conjunction with this lift. So I'm leaning towards D, hold for consideration, so we can do a deeper dive into what the priorities are. And then if the priorities have room for this, then we move forward with A.
Appreciate it. From that consensus from those that chose to share their thoughts and concerns in this area, at least my synthesis so far has been to hold consideration until the CS bars can meet again for the next year, and then potentially staff can begin a study of, what would the cost be of doing surveys for the students that would sit for the first year law students exam, as well as the schools. Does that match the consensus that others heard? Any objection to that?
Agreed.
So I just want to recap what I think the next steps would be. So doing a full-blown analysis would actually be akin to making that recommendation and prioritizing that full board of work. But maybe what might be appropriate is to do a survey or other engagement mechanism to get a little bit more information about the interest and the concerns, as well as the context of the other potential priorities that you may put forward when we come together again. Does that sound like a reasonable next step?
It does to me.
Yes.
Okay.
And anyone object? I'm a negative
No
person.
objection.
I always prefer to ask the opposite. Thank you. Thank you.
Chair Frickberg, it is noticed for action as a possibility. Do you want to take a straw poll or do a vote to confirm your sense to ensure that we've heard every voice?
We could take a straw poll, but I don't believe there's going to be a motion. It's helpful for our purposes publicly. We could take a straw poll. I would definitely, as one, recommend that. Could we do a roll call vote on just that straw poll from staff?
And there is a potential motion that is at the at the end of the presentation. That would be a waiting motion if there's interest in that.
I haven't heard interest in the actual motion. I think that we'll have to wait until the next
Okay.
cycle.
Very good.
So would we like to do the straw poll from staff?
Sure.
So again, the straw poll is concerning having staff do a survey of students and schools, and then we'll in essence table this matter until the next meeting of the CS bars for further discussion at that time in response to the data received.
Excellent. And we can use a show of hands. Not my hand.
Don't make me wait anyway.
Okay, and I'll verbally ask Dr. Bolton, who is here via phone, if he finds it acceptable to bring back further information and consider this proposal in context with other priorities.
I'm voting yes.
Okay, thank you. And then I see hands from Paul Kramer, Kevin Marshall, Philomena Yaroshak, William Hunt, Jay Frickberg, and I will just ask verbally, Dean Dolan, may I confirm what I believe I heard earlier, that your preference would be to have staff gather additional information through a survey or engagement mechanism and discuss this in context with other priorities at a future CS BARS meeting?
Yes, I'd agree. I would agree, or no objection.
Okay. All right. Thank you, everyone. I appreciate that informal step. We just want to make sure that everyone has weighed in, and I want to appreciate the work that Dean Hunt and Dean Dolan have done to date on this issue.
Absolutely, and thank you. So at this time now, we'll turn back to our Chief of Admissions, Donna Hershkowitz, for item 6.3. Just as a notation for all, it is now 2:07. We do have a special set for item 2.7 for the California Lawyers Association. So depending on how we progress, we might take a break at that 2:30 time for the special set.
And may I say, can you hear me here? I must
Yes.
excuse myself for this doctor's appointment. I apologize, but I will get the notes and review them thoroughly.
Thank you.
Dean Dolan.
Indeed. Turn it off.
So Donna Hershkowitz, it's all yours.
Mr. Chair, I noticed that Paul Kramer has his hand raised. I didn't know if you want to turn to him first.
I think it was just from the straw vote earlier.
Got it. Okay, this should be quick, I think. I wanted to bring the committee up to date on the discussion about admissions fees for 2026 and 2027. Just want to scroll down here and catch so what there were two items that were discussed by the Committee of Bar Examiners and the Board of Trustees at their joint meeting last week. One was a proposal to on a sort of as a temporary measure increase the fee for the application to sit for the February 2026 bar exam while the staff develops a more comprehensive proposal related to admissions fees. That was voted down with the Committee of Bar Examiners and the Board of Trustees wanting to have the full comprehensive analysis of needs for additional funding before they made took any action with regard to a fee increase. So let me take a step back here just for a second. You all will recall that starting at the end of 2023 and heavily at the end of 2022, heavily in 2023, the State Bar was exploring the need to increase fees for various admissions programs, moral character application, registering for the bar exam, registering to sit for the bar exam, registering with the State Bar, multi-jurisdictional practice programs, first year law student exam, etc. And what we did at the time was do a comprehensive analysis that looked at the revenue and expenditures related to each of those admissions programs. And that required a bit of work because it's not necessarily the way the State Bar budget or the admissions fund is set up. So, for example, most the staff are just sort of gathered in a personnel line in the admissions fund budget, but obviously there are significant percentages of time that some staff devote to bar exam related activities. And so in order to figure out how to allocate all of the admissions fund across each of the programs, it was determined what the percentage of time and therefore the percentage of staff compensation was that was devoted to each of the programs. There were other things that were divided up. Now, this is different. Some of you may have seen in the past when we have come to the committee of staff, have come to the Committee of Bar Examiners with the costs of the bar exam, right? What did this particular most recent bar exam cost? And if you take a close look at that, you'll notice that those are really direct bar exam expenses. They're the expenses for proctors, the expenses for the site. They are the expenses for the electricity that we need in order for people to power their laptops. They are not allocations for how much staff time is devoted to work on the bar exam. They typically don't include the costs for consultants for testing accommodations, right? All of those other costs. But for this exercise, what we were looking at was what's the condition of the admissions fund, right? Because the way that the admissions fund, the admissions programs are funded, all of the money comes from the fees that are charged. And so in order to figure out what what the fees, what level the fees should be at. And in this case, when we looked at it in 2022, 2023, early 2024 for the law school related fees, the fees, many of those fees had not been raised for a good 10 years. And so we were looking at what's all the revenue coming in and what are all the expenditures going out for each of these programs. And to the extent possible, aligning those revenues coming in and the costs coming out. There were some deviations from that. There were deviations in with regard to the amount that was being assessed for law school accreditation or regulation services, where we were continuing to subsidize to a small extent because the expenditures exceeded the revenue. There were other things where if we increase the first-year law students examination fee to the amount necessary to meet the expenditures, the staff expenditures and the expenditures on space and whatnot that are spent on that, we felt that the fee would be exorbitant. And so did not increase that particular fee as much as needed in order to meet the expenditures for it. That requires some shuffling to the extent that you need a budget that is balanced. And we are at a point where there's not a lot of give anymore in the admissions budget. I was thinking about a comment that was raised at the Joint Committee of Bar Examiners and Board of Trustees meeting, and realized that I was sort of missing a sort of an important way to explain this. And so if you think about the annual admissions budget as your checking account, right? This is the revenue that's coming in and the checks that are going out. That's your checking account is the annual budget. Your savings account is the reserves. And so to the extent that in 1 year that your expenditures exceed the income that's coming into your checking account, if you've got a savings account that you can draw from, it's not horrible, right? You can make it up from the savings account. We are at a point where the savings account is being depleted. And so for 2025, the expectation originally when we did set the budget was that there would be, I think it was $3.2 million that we would be adding to that savings account. Instead, as a result of a lot of action that took place after the February bar exam, as well as returning to fully in person for the July bar exam, we had a complete turnaround. And instead of adding money to the savings account, we are now taking $3 million out of the savings account. So as a result, the reserve fund is diminishing. Originally, the plan would have been to look at admissions fees to see if they needed to be increased, left the same, or decreased 3 years after they were first increased. So we would have toward middle or late part of 2026 done that analysis to increase fees for starting in 2027. We have to advance that analysis because of the condition of the fund. And so over the next couple of months, the Office of Finance is going to be working with the admissions office, and we'll be putting together a proposal that we'll bring to the Committee of Bar Examiners on what changes would be required to all of the program fees in order to be able to better balance the budget, in order to be able to create a bit of money in that savings account, in order to be able to account for things that are unanticipated. And so the plan will be that I think in October, ideally in October, we'll be presenting something to the Committee of Bar Examiners for presentation to the Board of Trustees Finance Committee and ultimately the Board of Trustees itself in November on what the fees would be for 2026. So we have to advance that for a year. And so we just wanted to bring you all up to speed that activity is going to be underway, and that you'll be able to hear what the proposal is at the Committee of Bar Examiners meeting, the Finance Committee meeting for the board, as well as the full board meeting. And I'm happy to take any questions.
Sorry, I got myself on mute that time. Surprisingly, I'm still not seeing any hands up. So thank you for that item for 6.3. And no, again, last chance, no questions or comments from our committee.
Thank you so much for your time, and I apologize, but I have a meeting that I need to get to. So thank you once again.
Understood and appreciated. Thank you. That brings us now to item 2.1 within our staff report on updates on the provisional licensure program with Tara Clark, who I believe is in our audience. I'm hopeful we can have that within our 12-minute time frame. I'm unsure. So again, just as a reminder, at 2:30 we do have that special set. Can we now promote Tara Clark, please? Thank you.
And good afternoon. Can you hear me?
You are good.
Thank you so much. So give me one moment to share my screen. And I think this will be quick. Okay, and just confirming you can see the PowerPoint.
It's not in presentation mode either, but it's not.
I think it's shared. Let me share it really quickly again. It decided to move to my other screen. So okay. Is that better?
Much.
Okay, so thank you so much. So this, for those who attended the webinar regarding the Provisional Licensure Program, this may look very familiar to you. I'm just going to go a bit more quickly. So just as a reminder, we now have 3 cohorts for the Provisional Licensure Program. We have the first group who we call our 2020 graduates. That program has been extended now to sunset in December 31st, 2027. Initially, they were set to end this year as well. We also have our Pathway to Licensure applicants. Those are the folks who scored between 1390 and 1439 in the bar exam, and they were able to apply for their program in early 2021. These are the ones who can be licensed through the program without having to retake the bar exam, and they have until the end of this year to complete that. And now we have our new folks, our February 2025 first-time bar exam takers who either withdrew from the exam or were unsuccessful on it. And so that application is set to launch on September 1st. And that program is also set to sunset on December 31st of 2027. And so this is just a really quick overview of the differences between the program. So both the 2020 graduates and the February 2025 bar exam applicants, they must take and pass the bar exam. So this is not a pathway to licensure. It just allows them to practice in this provisional capacity until they are licensed. They're not required to report hours, and there's no supervisor evaluation at the end. Whereas with our Pathway to Licensure applicants, they must complete and report 300 hours of supervised legal practice, and they have to receive a positive evaluation from their supervisor at the end of the program. Okay, and so specific to our February group, the timeline is a little bit tighter than we saw with our prior program, so we're really trying to get the information out there so everyone is aware of it. Again, as I mentioned, the application will open on September 1st, and then it will close on December 31st. So we have notified those applicants that are eligible for the program. We've also notified those who do not have a passing MPRE score on file, or either a positive moral character determination or an application in process. And of course, when they apply for the program, they must have a supervising lawyer. The fees, if you caught the joint bar exam, the joint meeting between the Committee of Bar Examiners and the Board of Trustees last week, they set the new fees for it. So those who are volunteering, they are unpaid as a PLO. The application will still be $0 for them. Those who are employed by an IELTS funded organization that's paying the fee is $600. For everyone else, it's actually going to be, in the typo on that slide, $1,200. So those fees will be reflected when the application opens on September 1st. And then, as I mentioned, there is a bit of a tight time frame for these applicants. So by December 31st of this year, they must have a positive moral character determination, or if they have an adverse, it has to be on appeal at that time. And they have to have a passing MPRE score on file. So that's a skilled score of 86 or higher. So if either of those requirements are not met at that time, if their application hasn't been processed yet, then it will not be approved. And if they have already been approved, then their license would be terminated at that time. So if you do have any students who are planning to participate in the program and have not met either the moral character or the MPRE requirements, we ask that you please encourage them to do so as soon as possible. Okay, and then our next two Requirements are both the May 31st, 2026 is the next big compliance date for these folks. They must have a supervising lawyer who's committed to supervising them through the end of the program. That doesn't mean that the applicants can't switch supervisors if something happens. It's just we can't have an end date prior to that. And then they must also complete the new attorney training program by May 31st of 2026 or within 5 months of approval, whichever one is earlier. And upon being approved for the program, they'll receive an email with those compliance dates, and they'll receive reminder emails along the way as well. Okay, and so the responsibilities of the PLLs have not changed. Again, they refer to themselves expressly as a provisionally licensed lawyer. They'll include their supervising lawyer's information on anything that they file in court with another tribunal. They are able to provide a wide range of services. It's generally left up to the direction of the supervisor, but that could include appearing before a court or tribunal, drafting documents, engaging in negotiations and settlements, and providing other legal work and advice. And then we do ask, just because some of them do forget, they are required to let us know immediately if their supervision by the supervising lawyer has terminated for any reason. The requirements for the supervising lawyer has also remained the same. So they must have practiced law for at least 4 years in any jurisdiction, and then also actively practice law or taught in California for at least 2 years immediately preceding the time of supervision. They have to be in good standing and work at the same organization as the professionally licensed lawyer. And I won't go down the rest of the list, except I will point out the last one again. The supervising lawyer also does have requirements, including that they must report to us any changes within 10 days. Like, for example, if they stop supervising the PLL for some reason. Oh, why is it not changing? There we go. And so we just wanted to bring out some of the benefits as well as that you've seen. So this is from an older survey that we did from a prior cohort, but the participants did gain real world experience. So 86% of them reported being extremely satisfied or satisfied with the program, and 89% agreed or strongly agreed that it was valuable in preparing them for the practice of law. The program's also been beneficial for the supervising lawyers. You can see that 92% were satisfied or very satisfied with the work of their professionally licensed lawyer, and 83% of them found the professionally licensed lawyers to be extremely hardworking. Okay, and so how can the law schools help? So we are trying to help encourage folks to use your resources as much as possible to help these applicants find placements, as well as we are reaching out to other organizations like the California Lawyers Association. We're also going to be doing a webinar with them as well to help raise awareness. So as much as you can, if we do ask if you're able to utilize your alumni networks or career services, just help raise awareness of the program, understand the requirements to answer questions, or reach out to us if you have any questions as well. We're happy to help. As I mentioned earlier, please encourage anyone that you know who's willing to, who is planning to participate in the program to submit a moral character application as soon as possible. And if they don't have the MPRE and they're not signed up for this August one, to sign up for the by September 25th for the last administration of the year. Okay, that was very quick. Are there any questions?
Dean Hunt?
If a student withdrew from the February bar exam or did not pass the February bar exam, but sat for it in June, in July, are they still eligible for the PLL program?
Yes, as long as they were a first-time taker for the February exam. So that just means that they could not have sat for and taken the exam prior to February.
Correct. Yep. They were, we have 2 that were first-time takers. 1 withdrew, 1 did pass. I believe both sat for the July exam. Obviously, we won't get those results till November, but if either one of them wanted to apply for this program, they could, and then they would do the 300 hours of study with a supervising attorney and become licensed that way.
So they, so I apologize. So this cohort, this is not a pathway to licensure. So this mirrors the 2020 program. So there's no hours requirement and it's not a pathway to licensure. Instead, it just allows them to practice under the supervision of a licensed attorney while they're trying to pass the bar exam. So
I see. Okay. Okay. Thank you.
And any other questions from our committee? I had one, again, just foreshadowing what students might ask all the time. The The provisional licensure program will open on September 1st. September 1st is Labor Day, a holiday. Are they still going to be able to access that online, or will it be on the next day, September 2nd, Tuesday?
So it should be on September 1st, so we are able to automate the system to open it. They're just may not, if they haven't run into an issue for some reason, they may not get a response to the next day, but some of us will be keeping an eye on it. So
Understandable, and thank you. Definitely appreciated. I do not see any other hands for questions or comments from our committee. So thank you very much for your presentation and for helping. It does help a lot of our graduates, and they in turn get to help their communities, which is excellent. So it's a great program.
thank you so much for having me. Have a great day.
You as well. And we're about 2 minutes early for our special set. I don't know if they are early.
They are not quite ready, so let's continue with the agenda and we'll check in after each item.
Then I will turn over to Audrey Ching for 2 minutes or until they arrive for agenda item 2.3.
Okay, can you hear me okay? I'm having a little audio. Oh, great. Yay. I feel great now. Okay, let me share my screen. And then you can also tell me if I'm in presentation view or not. Okay. Oh, it's no. How's this? Not in presentation? How's this? Anyone?
Excellent.
Okay. All right. So I'm doing a hodgepodge, but covering a couple different things. So waivers, the bar exam, study adjustment, July 2025, and then the future of the bar exam. Let's go on. So just a reminder, both the November bar exam study, the special session study adjustment, and the fee waiver related to those February 2025 applicants that withdrew, those can be applied to any of the exams in 2026, so February or July, but they can only be used once. So if it was already applied, if the adjustment was already applied in July 2025 or the fee waiver was used, those have expired. But just a reminder that for people who still have yet to apply that adjustment from the November study or the fee waiver, it can be used February 26 or July 26, but again, only used once. Very high level about the July 2025 bar exam. I went into this more in depth at the August 14th joint meeting, which is posted and recorded, but just very high level. The exam administration proceeded as planned across all the standard sites and all the accommodated applicant sites. No major disruptions, no systemic problems. The typical issues we've had every year we do an in-person exam with proctors, with test takers across different sites. Those typical one-off issues were present, but the staff, the applicants, the proctors, teams, everyone on the ground adapted as needed to address all those unique issues. And so overall, an uneventful July 2025 bar exam. By the numbers, by the time we began the exam, 574 withdrawals or no-shows. So that made our total attended 7,741. Out of that, 1,037 were accommodated applicants. And we had recruited on our side 1,318 proctors, and then we had to use 245 Robert Half temps to fill the gaps at all our sites. This is a busy slide, and I apologize, but we talked about, I'm moving on to some of the items that were talked about at the joint meeting concerning the future of the bar exam. So please, I may not see your hand, but stop me if you want to stop me. But this was all the guiding principles that the Board of Trustees adopted at their meeting in May. And so at the meeting last week, the joint meeting between the Committee of Bar Examiners and the Board of Trustees, the guiding principles were up for adoption by the Committee of Bar Examiners because they had yet to adopt what the Board of Trustees had adopted in May. So we went over these guiding principles again, about how to make decisions about the future of the bar exam, including some things that are not compatible with delivering it just twice a year on the National Conference of Bar Examiners schedule, because you considering remote options or considering an exam that can be delivered more than 2 times a year. I actually see your hand, Dean Hunt, 1 second. And the one thing that the Committee of Bar Examiners added last week was an additional principle on their side to avoid locking the state bar into long-term vendor contracts so as to provide flexibility in licensing innovation. So that was adopted along with this, the rest of the principles last week. Dean Hunt?
The number of proctors, I guess, 1,500 proctors.
Yeah.
Can I ask how come it takes so many proctors for 7,000 students? I would figure you probably have, a couple of hundred students in an auditorium with 2 or 3 proctors. The ratios really, I mean, almost 7 to 1.
Right. Well, I haven't disaggregated for standard versus accommodated. So yes, the standard sites have a much higher ratio of folks who can look at a large convention center and, be walking around a couple rows at a time. Also, it's not just the exam floor, but we have a workroom where we have proctors hired to run sort of the logistics of the workroom and how all the supplies need to go in and out and be packed appropriately by questions. So there's some proctors that are not even on the floor that are working in the workroom. And then the accommodated sites have a lot higher ratio. Some of our accommodated applicants have private rooms, and that's a one-on-one proctoring situation, or a semi-private room, which again is a very high ratio. We do have reduced distraction rooms, but it might be a room of 15 applicants and then so many proctors. So it really, the ratios really go up based on the kind of the layout of where we're testing. We have some accommodated applicants in hotels and hotel rooms, or we have some in classrooms. So it really, you're right, the ratio is very high, but it could be, and maybe in a future time I bring this slide to you, I will disaggregate so you could see the proctor ratio for standard versus accommodated, but that is, that's some good math, and that is kind of how the layouts kind of demand depending on the situation of how we're proctoring and how the applicants are testing.
Obviously I would assume that is the enormous expense that is resulting in the admissions shortfall that Donna Hershowitz was just talking about.
Right. So there were a lot of factors coming out of the pandemic. So during the pandemic, all of those event centers and hotels were not getting business. And so as we returned to in-person testing, a lot of their facility room rental rates have gone up. And then we're not an event that does food and beverage. So there's a lot of different things about administering the bar exam with the facilities that are expensive because we don't bring in some of that other kind of auxiliary revenue. And then the hourly rates in California for that temp agency I talked about, Robert Half, and then for recruiting on our own, those skyrocketed after the pandemic as well, where we had to raise what we paid those temporary workers for the exam. So yes, a huge cost center is those temporary workers, the proctors, and then the facilities are also expensive.
Has the number of students seeking accommodations gone up, way up? The 1,000 out of 700, it seems like a really high ratio. I was a student that got accommodations throughout college and law school and on the bar exam. So I'm not saying it as a negative. I guess I always thought it was around a couple hundred students that were getting accommodations. I didn't realize it was such a high number.
Yeah, I mean, this is the highest. I mean, you look at that, and that's who attended. So we had 1,300, I think, that we approved, and then we had the no-shows and the withdrawals. So that's who attended, was 1,037 out of the 7,700 or so at the exam. So yes, that was a much higher percentage than we had forecasted. And then nationally, the trends for licensure exams, and I'm sure, as you know, accommodations at undergraduate and at law school, it's increasing. So it's something that we have to plan for because the trends are there that there will be more and more applicants who are seeking and will be approved for accommodations in the future.
Yeah, back in the olden days, I think it was me when I was in law school. There was me. I didn't know anybody else who had accommodations. I would assume that has changed dramatically, but Okay, I just wanted to ask. Thank you.
No, I appreciate you asking because I think all of our presentations are sort of aligned today about, putting things together about what are the drivers for our cost centers, and
Yeah.
then this whole idea of the future of the bar exam. It's thematic. So thank you for stopping me.
Thank you.
Okay, so we talked about the guiding principles, the CBE added this addition, and then Donna in her presentation, this is just the same slide she showed last week, talked about options. What are the options in front of the Committee of Bar Examiners and the Board of Trustees about the future of the California Bar Exam? There is a standing court order. The Supreme Court had an order from October 2024 ordering California to develop its own bar exam. That was after the Blue Ribbon Commission. So there's an option to take a bridge to the new bar exam that we develop, return back to Kaplan Exam Services, developed multiple choice questions, continue with the California developed essays and performance tests, or reconsider the National Conference of Bar Examiners Next Gen exam. That exam, the new iteration of the UBE, now called Next Gen, is a day and a half, and some jurisdictions are going to add on 3 hours on that second day, so another half day of their own state-specific content. So that's something to consider. Or is there a third option to really streamline the new bar exam, sort of meeting the requirements from that court order, but streamlining it to just 100 multiple choice questions and 3 performance tests? Or is there some other streamlined, easier structure to consider? So those were options discussed, no decisions. Up next, we have to conduct an in-depth cost analysis to put forward for the Committee of Bar Examiners and the Board of Trustees over the next several months. And then it was discussed that the last administration of the MBE, the last time the National Conference will allow the MBE to be delivered, as they are phasing everything related to the current UBE out in favor of Next Gen, is February 2028. So in order to give 2-year notice, we need to give that notice on the future of the bar exam by July 2026, which is 2 years from when we will never, and we won't be allowed to use the MBE anymore because it won't exist. So July 2028 will be at the administration where we need to decide on an option. July 2028 is also the Los Angeles Olympics over the exact same dates in July as the bar exam is planned. So lots of future planning needed for July 2028, regardless of what exactly we decide on the future of the bar exam. Any questions? Yes.
Can you move the bar exam so it's not at the same time as the Olympics?
So so if we had a flexibility, so it all depends, right? So the National Conference of Bar Examiners, they have a form of their test, right? So that's why everything is delivered nationally at the exact same time, because they have one form of the test. Everyone has to take it at the same time. They don't have multiple forms. So if we did Next Gen and everyone across the country is taking it the same days in July, that is exactly the same days as the Los Angeles, Olympics. And then that would be, maybe we wouldn't have any test sites in Southern California. Who knows how we would administer it to counter program the Olympics, right? So if we had enough notice to change the date of our own developed exam by 28, that could be something different, but that's just throwing it out there, as the Olympics is, already pretty planned for 2028. So we also need to catch up with our planning.
We're here in Santa Barbara, and there's events up here.
Right. I think that's right. I think when you say Los Angeles, in terms of where those kinds of Olympic level venues can be found, it doesn't just mean LA County. It's all over Southern California or more. Yeah.
I know we have an Olympic pool out at UC Santa Barbara, and Olympic diving boards, and then dorms that'll be empty. Athletes are going to be staying and training out here and then getting bused into Los Angeles. So there isn't a hotel room in Santa Barbara available. It'll spread down to San Diego.
I'm also thinking San Diego will be a very difficult location to find event space for the exam. And of course, any applicant that normally wants to get a hotel room themselves, I think that'll be extremely difficult. So yes, I think regardless of options and what's going to happen with the actual content of the bar exam, July 2028 is a head scratcher for us to compete against the Olympics.
And then just to chime in with the slide where you had the 3 different testing options, one of the things that I have discussed with people over the years is the number of essay questions that really are required to tell if somebody's capable of being an attorney. And the one with the 3 performance tests seems adequate. You can tell if somebody's capable. I've also said repeatedly that I'm not sure somebody being able to memorize 15 subjects and then be ready to write essays and multiple choice questions on those proves that you're a capable attorney. It proves that you've got a really good memory. But whether that establishes that you're a good attorney or not, I don't think does. I think 3 performance tests should be more than enough. The uniform bar exam is great because it gets licensing in other states, but you know, we'll work that out. I guess sometime between now and July of 2026.
Right. So we need to get that 2-year notice by July 2026.
That's not that long from now.
That's right.
Okay. All right. Well, let me know what I can do to help.
Well, our committee of bar examiners, Representative Paul has his hand raised.
Yeah, Audrey, last week at the joint meeting, it was not clear to me that we had settled on waiting until as late as July to give the notice. So
That's the
has that been
latest we can give the notice. You're right. We could give the notice earlier. That's the latest with the 2 years before July 2028.
Okay, I was wondering if something had changed because
No.
I'm very much in favor of taking more time to figure out and not trying to give the notice to be able to give our own exam if that's our choice in February. But
Yeah,
okay,
the
so
latest
nothing
for
really
2
has
years.
changed.
Yeah, no, sorry.
Okay,
Sorry if I was
thanks.
went too quickly over what I was saying, but yes, the latest we could give before, for 2 years for July 2028 would be July 2026.
Yeah, you got my hopes up, but now you've dashed them. Thanks.
But I think the more time to deliberate, these are important decisions. So I think you're right, Paul, the more time to deliberate and to have more meetings to discuss the consequences of any of these decisions is important. And obviously the feedback from the law schools is also very important. So.
And 11 months will be here in the blink of an eye as we go through that process. So I wish us all well on that endeavor. Absolutely. Any further questions before we check to see if our CLA representative is here for their special set?
I have a hard stop at 3, so I'll just quietly go away if I have to. But
Okay, so we've been adjusting the schedule to address various time commitments, but one thing we should do before everything changes is to review the minutes. So if we could quickly do those before moving to our 2 guests from CLA and also from Access and Inclusion, that would be terrific.
Absolutely. So we'll turn to agenda item 4.1, approval of the minutes from the June 18th Committee of State Bar and Registered School Session minutes. Those minutes have already been dispersed and were posted. So everyone within this group should have already had access to time and go through them. Is there a motion to adopt or discussion of the proposed minutes?
So moved.
Seconded.
Can we have a roll call vote, please, to adopt?
Dr. Bolton? Oh, I think he's on mute. Let me. Dr. Bolton? Maybe we'll come back. Dean Dolan is not present. Dean Hunt?
Yes.
Paul Kramer?
yes.
Dean Marshall?
Yes.
Dean Yaroshek?
Yes.
Dean Frickberg?
As permitted under Rosenberg's rules? Aye. Yes.
And I
Excuse me, Jim Bolton is in now. I was muted at first. I vote yes.
Thank you. That is a yes for Dr. Bolton. With 7 ayes and 0 nays, the motion carries.
Thank you. So if our guest from CLA is here, I think we can
Yes.
move on to agenda item 2.7.
Yes, I'd like to welcome Jesse Fierro from CLA. And we're on our way to promoting her now to talk about a number of opportunities for law students through CLA.
Thank you. Can you hear me? I think I'm here now.
Yes.
Got a little confused with the whole panelist thing. Thank you so much for giving me some time today. I know I don't have a lot, so I'll try to go quickly. And I'm not appearing on behalf of the California Air Resources Board. I am, in fact, here to talk about the California Lawyers Association. I know you've all heard of us, but we just wanted to take an opportunity to remind you all that we're here. And one of the things we get very excited about is supporting law students. When I think about my own CLA journey, I'm here at CLA because of the content, community, and service opportunities I get through this organization. And one of the best ways our attorneys can give back is by supporting law students and the things that law schools do. So many of us went to California law schools, and we want to lift up students the same way that others lifted us up in our journey. I have just a few slides. I'll go through them very quickly, and I did provide them so that you should have access to them as well. Normal. Oh geez, so many things. Okay. So CLA for law students, am I gonna actually be able to? Gonna take like all 5 minutes just messing with this. I'm just gonna scroll through it the old-fashioned way. Okay. So one of the things we wanted to make sure you all knew was that CLA is free for law students. And so every law student, and you don't even have to be California law students, although we love our California law students very much. Every law student can sign up for the California Lawyers Association for free. They can choose up to 3 sections and then get the benefits of membership. And I'll explain what that means in a second. But as a reminder, we have 18 different sections that law students can choose from. I've served as an adjunct law professor myself for San Joaquin College of Law, Monterey College of Law, and I tell my students all the time that being a CLA member, you get email newsletters, you sometimes get print publications, you get reduced rates to attend conferences, and you start learning how to network beyond the networking that you get at your own school, and that can be really invaluable. You get to see what kinds of issues people in your hoped field are talking about, and you get to be on the cutting edge of some really important legal development. So even if you don't know for sure what you want to do, pick the one that you would really love to do, pick one that's a good, fallback, and just pick another one that sounds interesting. You can change from year to year as you renew your membership. And as a member, beyond just getting like the content, the emails and the publications and reduced conference rates and things like that, there are a lot of specific student opportunities that have existed for many years, and we're making new ones every day. We have summer fellowship programs through several sections that give students a summer stipend, usually mentorship that helps place them with an organization. There's a wonderful student reporter program through the intellectual property section, and we're starting to mimic this in other sections as well, where a student applies and is selected, and they get mentorship in their writing, and they get free conference registration, they get writing opportunities, and lots of bragging rights. So that's a really vibrant program. And I hear that the mentors and mentees still stay in touch with each other. Like these develop into lasting relationships, which is really exciting. There are writing competitions. There's a student corner publication series through privacy law. The environmental law section has a negotiation competition. We have mentorship programs, reduced or free registration for students at many events. And at like the major conferences that tend to cost a little bit more, there's also scholarship opportunities for students to apply to. We have 101 level at webinars across sections that introduce students and new lawyers to various fields of law. And CLA leaders are available to work with you and your professors in your schools. If you ever need like a speaker on an issue, you want someone to visit, if you want CLA to visit, if you want a short article for student publications, either about an emerging legal issue or just about CLA in general, we have people who can do that. I want to talk very briefly about the mentorship program we just did this summer. I worked with Natalie on this. We had graduates of closed law schools, and we were looking for mentors just to give them some moral support as they studied for the bar. We were able to turn this around very fairly quickly. It's the quickest we've ever put together a mentorship program. We had a good handful of students apply, and I didn't have enough mentors at first. But then I went to that brain trust. I went to our membership and I said, "Hey, I have some graduates who want some mentorship. Is anyone interested in volunteering?" And I had 15 volunteers I had never met before within 15 minutes. Like, it was astounding. Lawyers are here and they want to help the legal community by helping students and legal recent graduates. So I think there's a lot of room to do even more. I do want to also know that upon licensing, once they do pass the bar exam, CLA hosts or participates in swearing in ceremonies. We have a new lawyers section to provide support for newer practitioners. The tax section has a young tax lawyer committee and so much more. So I truly believe that CLA is the place to be if you are a law student or if you're a new practitioner. So how can you, as someone at a law school, stay up to date on what's going on? Well, one way is we do have a CLA law students on the link. We have a LinkedIn page for this, and any section that does anything for law students, we post it here. So regardless of what section you personally are interested in, you can get all the updates for law students on this LinkedIn page. We're thinking about starting like a quarterly newsletter. You know, there's updates on the web pages. So there's lots of things that we can do to work with you and law schools to support students and get them excited about their upcoming network and profession. That's all I have for today. I know your agenda is impacted, so I'm going to stop sharing this for now. I'm happy to take questions now. I'm happy to take them later. I know Natalie has my email address. You're welcome to share it with anyone who has a question about CLA.
And Jesse, just a quick question. Your annual meeting this year is in Los Angeles, very close to many other
It
schools. So
is, yes, it is at Universal City. It is scheduled for September 11th through the 13th. We have a student reporter from UC Davis who's going to be attending and writing about that conference from the students' perspective. So I expect some great articles from her about the annual meeting after the fact. So we're very excited about that. Thank you for asking.
Just a quick question. I was pretty sure I heard you say you don't have to be a California resident. All of our students are scattered around the United States. We're online.
Yeah. Yeah, you can if you are a law student at an accredited law school, you can and does not limited to California, you can be a member of the California Lawyers Association.
and also a registered unaccredited law school as well. Yes?
Oh yeah. Mhm.
Great.
Great. Thank you. Thank you.
Thank you. If you ever have any ideas on how we can support students at your school, shoot Natalie an email and tell Natalie to get you in touch with Jesse Fear. I'm the incoming chair for the Board of Representatives, and supporting law students is one of my passions.
And
So I look forward to
Jesse,
working with you.
Jesse, may I share your email in minutes
Absolutely.
and with
Yes,
the
indeed.
picture? Perfect. Will do.
Thank you so much, everyone.
Thanks, everyone.
Thank you. We'll now turn to agenda item 2.5 with Natalie Leonard.
Just very briefly, I'm reminding people that this is the second year in which unaccredited law schools will report the NPR in a non-binding way on their 6061 disclosure. So accredited law schools have provided their NPR values for 2025. They'll be discussed on Friday at the Committee of Bar Examiners in a binding manner. The staff report is already posted. We're pleased to say that all accredited law schools met the target threshold this year, and that will be exciting to share with the committee. And then for unaccredited law schools, they'll receive the materials they need to calculate their NPR as part of the packet for the annual report that will be distributed to them in September. So that's what I've got there.
Excellent, thank you. And our last agenda item is a report on opening the application period for the State Bar DI seal for employers. I see that Ms. McCrae is in our audience. If we could promote her, please.
Hi, good afternoon. All right, I have just a couple slides to share. I will be very brief. I have about 2 slides total, but if you'll give me just a moment to get those pulled up. All righty. So my name is Danielle McCrae, and I'm a lead program analyst in the State Bar's Office of Access and Inclusion, which, among other things, leads and contributes to the State Bar's work as it relates to diversity, equity, and inclusion, and access to justice. As I think many of you know, the State Bar launched a DEI Leadership Seal program in 2023. It's a program that's available to all legal employers that employ California attorneys across the legal sector. And to participate, employers must commit to and implement at least 5 of a list of 10 action items. And those action items are activities, tasks that we ask employers to do to increase diversity, equity, and inclusion among their workforce for their employees. And so there's some different tiers to the program depending on the number of those action items the employers choose to implement. Employers first can start as a committed participant. They can commit to at least 5 of those and they're kind of in the door. And then once they implement at least 5 of those action items, they then can be recognized as a SEAL recipient, bronze, silver, or gold, depending on the number of action items. And I am here today just to share with you that the 2025 application cycle for the DEI Leadership SEAL program is now open. We currently have about 85 employers participating. That includes several law schools or legal clinics, or a handful of law schools and legal clinics, the colleges of law, University of West Los Angeles, and then the Catherine and George Alexander Community Law Center at Santa Clara Law. And just wanted to flag for you all and your colleagues and the community at large that these applications are now open and will be open until September 23rd for new employers that are interested in participating. So if you or any members of the public that are watching want more information about the program, there's a robust webpage on the State Bar's website about the DEI Leadership SEAL program. And Natalie, also feel free to share my contact information with any committee members that may want to chat about this further. Happy always to talk about this program.
Thank you. And since we have the benefit of Dean Frickberg here, Dean Frickberg, do you have any tips or thoughts about the program and what it has meant so far to your school?
Well, I can speak for UWLA and hopefully amplify and echo what Ms. McRae has already mentioned. We don't always think of law schools as employers of lawyers, but we are. All of our faculty are lawyers, and especially for the registered schools, the accredited schools, I think diversity, equity, inclusion has already been part of the DNA of these schools before those were even phrases. So I think these are things that our schools do and do well. So this gives us an opportunity to show and to discuss that with the public at large. So I'd encourage everyone to participate, or at least look into, if not participate yet. And any other questions or comments from our committee with our one remaining minute to still be on time? So excellent. Thank you for everyone. As all of our agenda items have been now completed, although out of sequence, they are completed. We now stand adjourned. Thank you all.
Everyone.
Yeah, everyone.
Good to see you.
Have a good day.